I'm Gary Tabakman. I've handled hundreds of federal sentencing cases, and today I'm going to tell you the 9 effective strategies that you need to know leading into a federal case that can help you best achieve the results that you want in a federal sentencing. Whenever I meet with clients at the initial stages of a case, they always have the same question. What is it that I need to do in order to prepare myself, and what can I expect in the future? What a lot of lawyers don't do, and what they do not do effectively, is give clients realistic expectations, but also walk them through in a step-by-step method to allow them to understand what to expect in the short run and in the long run. They also do not understand or explain to them the necessity of knowing how their case will develop and what can be done earlier on in order to be able to salvage certain things for the tail end of a case that could help achieve a better outcome in your sentencing. The very first thing that we would do, depending on the information or in the indictment that's filed or the potential charges that you're seeking even throughout the course of an investigation, is communicate with clients about the federal sentencing guidelines. These guidelines will dictate how you can calculate a potential sentence in your federal case. The determining factor is always within the confines and the structure of this particular table that's always located in the very first page of any guideline manual. This table will dictate and will let you know whether or not your case falls into a status of potential probation or prison sentence. There are multiple things that go into calculating these ranges, much of which has to do your background and criminal history, and obviously the severity of the case and the type of case that you have. I will do a separate video regarding the calculation on your potential guideline range depending on the type of case that you have, whether it would be a fraud case, a drug case, or any other type of case that may involve a crime of violence and other enhancements. And what I specifically want to do is talk about enhancements in a separate video. Today, what I really want to focus on is what do we need to do in order to calculate the guideline range as a number one factor in order for me to help you understand what you may be facing. So in order to determine the base offense level, we look at the statutory provision that your crime is charged under. We then look at certain enhancements, criminal history, possible reductions for acceptance, your role in the offense, and what's called a safety valve. These are all tactics and things that we need to be able to communicate early on about, so that way you feel comfortable in understanding that there is a worst case scenario and then there is a possibility of a best case scenario, which is obviously something that you're seeking. Many individuals need to understand this because the worst case scenario usually involves you going to trial. You go to trial, you're oftentimes facing what I like to call as a trial penalty. So if you decided that you are not seeking a plea agreement, you decided that you're going to test the system, which is your right to do so, and you choose that the trial may be the better strategy for your case and for your situation, you are likely facing a more severe punishment at the tail end because you do not get the advantage of certain options that are available to you through the guidelines, which is available in a fashion for you to be able to achieve a better result. Now, is that fair? Probably not. But the reason that it exists is because the government and the Federal Sentencing Commission has decided to provide a vehicle to individuals to avoid going to trial and to face more harsh punishments by accepting responsibility, especially earlier on. The second thing that I would discuss with clients regarding what I consider as far as you being able to obtain a much better result in a federal sentencing is reviewing and objecting to what's called the pre-sentence investigation report. So even at the very first meeting I have with a client, I explain to them that the tail end of this process involves a meeting between the United States Probation Office that drafts a PSR report, which is a pre-sentence report, going to the court, which gives the court the ability to make an assessment of what the guideline range is, why that guideline range is properly calculated, and also provides a whole slew of information regarding your criminal history, your family background and circumstances, potential drug use history, rehabilitative efforts that you've tried to accomplish in the past, and obviously the facts behind the case. And then there's a section that specifically goes into discussing your role in the offense, the base level offense calculation, and enhancement points and reduction points. These factors, it will influence the ultimate outcome in the case. And what we discuss at the initial stages when I sit down with clients is for them to be able to understand that there are things within the PSR report that we can object to and provide a much better perspective to the court from our position as to what we believe the correct sentence should be and why we are advocating for you to receive the sentence that we are requesting. If these conversations are had early on, the client's expectations become much more reasonable and understanding of what the work entails, and also an understanding of why it costs so much to hire a lawyer in a federal case because of the amount of time and effort that will actually have to go into processing every single one of these little things that we need to do in order to accomplish the result that we're seeking. The third thing that we discuss is collecting mitigating evidence. What is mitigation? Mitigation is a process in which we attempt to highlight the best possible qualities of an individual. You are not a case number, you're a person. It's important for the court to see you as a human being, and the way that we highlight that is by bringing characteristics of your personal history to light in order to make sure that the court really finds you to be a person that has such qualities that are redeemable and that has qualities that shows the court that the chance of you recommitting an offense and your chance of recidivism is actually much lower than someone else. So what do we need for that? Oftentimes, we gather character letters, personal history documents, mental health records, and evidence of ties to the community. There's a whole slew of things that can go into this space, including, but not limited to, your background, work history, certificates of accomplishment where you may have accomplished certain things, military history, your ability to have overcome a significant challenge in life, your involvement with a religious organization, anything that you believe will highlight you as a person and can show the best possible qualities of who you are will be used as mitigation evidence. We should start gathering this very early on in the process. That will help achieve a much better outcome in the long run. The earlier we start doing that, and the more we start working on that as the case is pending, the more likely we are to be able to highlight certain things for the court and for the prosecution in order to get you a much better result at the tail end of this process. Now, why is this important, and why do many lawyers fail at this? Well, most importantly, a lot of lawyers forget that this is a very personal process. A lot of lawyers look at this situation as an individual has been charged with a crime. My job is to navigate the case, get the discovery, prepare for hearings, prepare for trial, and then prepare for sentencing. Most federal cases will always end in a sentencing. It's very rare that a case will not end in a sentencing of some sort. Your ability to start preparing for sentencing should start at day one. So the way you prepare your client for sentencing from day one will achieve a much better result at the very end. So I always tell clients that you need to be able to communicate with lawyers about this from the get-go. That will give you much better comfort level with who you're hiring, so that way you know that your lawyer is understanding of the process and has your back in order to be able to get you to the place that you want to be. The fourth thing, which aligns closely with mitigation, is a show of rehabilitation. There's oftentimes documented treatment, education, employment, restitution efforts that have been made. Depending on the type of case that you have, your rehabilitative efforts to overcome the challenges of the type of case that you're charged with will highlight a very significant element of who you are as a human being, and can also help the court understand the efforts that you have made in showing the true level of remorse and the true level of your ability to overcome this significant hurdle in your life. And obviously, very much depending on the type of case, it's a show of you being sympathetic to the needs of victims in your case, the family members, the government, whoever else may be involved. Much more importantly, so yourself. Because at the end of the day, you being able to show that you have taken the extra steps and the extra level effort of taking it upon yourself to change something in order to help the outcome of your case personally is a really huge indicator of who you are and will allow a judge to understand that you are truly remorseful and you're truly serious about taking this case in such a way to where you obviously want to overcome the situation and help yourself achieve a much more lenient sentence that comports with who you are and with what you actually deserve as a sentence. The fifth thing that I discuss with clients that can help with sentencing and the tail end of sentencing is drafting the sentencing memorandum and how we communicate with the court as lawyers to advocate for you and for your family. The sentencing memorandum will emphasize the 18 U.S.C. 3553A factors. You could click on the link right here above to view a video of the 18 U.S.C. 3553A factors that I'd previously done before, where I specifically break down certain factors that can help highlight who you are and the significance and importance of those factors and how they play a role in your offense. These factors will always be discussed within a sentencing memorandum and also within the pre-sentence investigation report that the probation department will draft for the judge to consider the appropriate sentencing guideline range and a recommendation of that guideline range. We have an opportunity to bolster the information that's in the PSR, and we do so through the sentencing memorandum by providing a lot more information to the court within the guise of that 3553A factors. The factors are probably the most essential part of being able to achieve the result that we're seeking. Those factors will discuss not only your background, but we'll discuss certain balancing acts that the court has to take into consideration, obviously including avoiding sentencing disparities in similar types of cases, your role in the offense, the way that the offense unfolded or the way that the actual allegation of the crime unfolded, what had occurred, who was involved, when and how your role fits in squarely within that space. This is all discussed and is all part of those factors. In addition to that, within those factors and also within the sentencing memorandum, we can discuss certain BOP programs, facility placements. We will discuss your background much more thoroughly with respect to the character evidence that we can provide and how we can help highlight you in a positive light, much more so than what the PSR may have or what the government may have provided to the court in order to make the assessment and the ultimate final determination of what your sentence will be. The sentencing memorandum is, in my opinion, the most effective and the most essential element of what your case will need in order to be able to help a court understand who you are. Oftentimes, within that sentencing memorandum, what I have done previously is I've provided live videos. These live videos can help highlight the reality behind who you are or who your family is. I've provided videos of clients that are speaking about themselves and speaking about the case, because the space of when you enter a courtroom to communicate about who you are can be incredibly intimidating. Doing a video that's inside your lawyer's office or inside your own home to communicate to the court about what may have happened or how you position yourself in that space, your remorse, your future, how this is impacting you. We have an opportunity to script this out, and it may be a much more effective way, depending on who you are as a person, to communicate with the court so they could really feel and understand what you're going through. These videos can oftentimes also include family members, other individuals that are closely connected to you that can communicate with the court, because these individuals don't come to court to testify. So the only thing that we provide to the court oftentimes in the course of these sentencing memorandums are character letters, and character letters sometimes can only go so far, because obviously a judge is a human being, and our attention level and our attention span may not necessarily be so hyper-focused on constant words, and especially words of similarity, to where you may have 20 character letters where individuals have written things about you that seem very, very similar in a way. Obviously, all of these individuals that are writing, they're writing positive things, but I don't want to read 20 letters that say the very similar things over and over again. Just as an example, I know John Doe, he is my nephew, or he is my son, or he is my coworker. I find him to be a really incredible person. He has always been there for me. A lot of these letters, they say very, very similar things, and it's not to say that they're not honest. They very well may be. But if you could put a person in front of a camera and provide a video representation of who that person is, and people actually communicating to the court about who the individual they're seeking to sentence is, it gives the judge a much better understanding and a better feeling about how to proceed, because they have now been able to put a face to the letters that have been provided, and it's a space of honesty and sincerity. And I think that the emotion actually takes over and really helps develop where we're trying to head with requesting our sentence and why we believe that it's important. The sixth most important aspect of your sentencing guideline calculation will be cooperation. So within the guideline manual, oftentimes what we know this to be is referred to as a motion for 5K 1.1 departure under Rule 35, early acceptance to reduce an offense level as well. There are certain things that go into that space that are far more complex than can be explained in this very short snippet of a video. Under a 5K 1.1, it is a motion that the government files that specifically states that you have cooperated and you have assisted the authorities in order to be able to either make other cases of similar nature or assist the government in concluding the case that they have filed. Oftentimes, this is within a big conspiracy case where you may have had either a major or minor role. You may know information that the government does not know, and you have sat down with the government and cooperated, and you're getting points for that cooperation. This is a discussion that's had early on. It is a discussion that's very sensitive because obviously the cooperation with authorities against other individuals who may potentially be dangerous in certain cases is a very sensitive topic. Many individuals, rightfully so, choose never to cooperate. It is not something that I, as your lawyer, will advocate for, but I will always provide the option to you, as it is my job to provide that option to you. And I will also explain the potential time reductions that you can receive in the event that you effectively cooperate and provide the government with essential assistance that can help you in the long run and can help your guideline numbers go down significantly. These reductions, they can stem anywhere between 10 all the way upwards of 25, 35%, just depending on the level of cooperation, the level of assistance that you've provided, and how the government feels about the honesty and the truthfulness of what you have provided to them. Again, this is a sensitive topic. If you feel like you have an attorney right now, or you're looking to hire an attorney that is not properly expressing this sentiments to you or explaining the context of what this all looks like to you, feel free to call me and I will help guide you better in that direction, and hopefully you can get a much better understanding of what you need to do in this context. The number 7 thing that we discuss, and I tend to discuss this earlier on as well, is communicating with the court from yourself and how to prepare for what we call an allocution. So we have to start crafting a sincere, remorseful statement to the court. You need to start practicing your delivery early on, because the way that you communicate and what you say is genuinely a very, very serious thing that most federal judges take into consideration. Federal judges are always the ones that will ultimately decide what your punishment is going to be. You want to make sure that you can address the court in such a way to where the court feels that you truly are remorseful, that you have addressed elements within the offense. If they are, for example, if there are victims within your offense, that you can address the victims specifically, that you could talk to the victims, that you could tell the victims that you're truly sorry for what has occurred, or that you can truly tell the government that you're sorry for what has occurred and what you've done, or your family members, whoever it may be, that you can communicate to the court about yourself, what you have learned, what you have done leading up to sentencing. So if you have this conversation early on with someone, and for them to understand, even if we're thinking we're still going to get ready for trial, This isn't a case that's going to just go to sentencing through some sort of plea agreement. We still have to focus on trial. But what I always tell people is if you start focusing on yourself earlier on, and if you start making decisions that can help you highlight yourself in the best possible way before a court, in the long run, you get the added benefit of that. Here's what I've learned in the last year and a half, 2 years. Here's what I've done. And here are the steps that I've taken in order to better myself. I'm not perfect. I've made mistakes. And I know the mistake that I made in this particular case. And I don't make excuses, but I want to talk about the factors that led me into the position that I find myself before you here today. If you can do that effectively, and if you can start crafting your position to the court in a manner that's truly sincere and honest, it does buy you benefit with the sentencing judge, and it helps the sentencing judge make a determination of what the appropriate sentence is. And I've spoken with federal judges about this particular issue outside of the court context, and federal judges oftentimes will tell you that the way that a defendant before them communicates with them and what they say can have a profound impact in the way that judges think about the sentence and what they ultimately conclude the sentence should be. The eighth factor that I tend to discuss with respect to sentencing and what sentencing looks like is managing court optics. So what I mean by that is presenting yourself effectively. It could be how you dress, appearing to be respectful, to show the court that you have visible, overwhelming community support, meaning getting people to show up at the court inside the court with you, whether it would be for a hearing prior to sentencing or during trial or during sentencing, showing that there is an overwhelming, loving, nurturing, care, supportive base of group that is there with you, that is there for you, is a very huge indicator that these individuals that have come to court, that have taken the time out of their day, that have taken all the necessary steps to show that they really care about who you are. These are the kind of optics that we want to be able to highlight, that we want to be able to focus in order to help you become the individual that we are describing you to be in our sentencing memorandum and in the character letters and in the videos that were provided. This is just one additional layer that can help a federal judge determine the honesty and the sincerity with which we have portrayed you to be, with which you have portrayed yourself to be. So oftentimes early on in the process, as I've said multiple times throughout this video now, I will sit down and communicate with clients about the significance and importance of communicating with family members and expressing to them the necessity of their participation in this process. It can help. And it could be a really huge benefiting factor to you. The ninth factor that I consider to be incredibly important for purposes of sentencing and communicating about sentencing is a plan for post-sentencing relief. So earlier on, I do talk about preserving certain appellate issues, considering compassionate relief. We also discuss what is a Rule 35, which is, again, another thing that I will discuss in a separate video because that could be complex and convoluted in it in itself, and then focus on certain reentry programs. So there is no parole system through the Bureau of Prisons and the federal system. So we have to start talking about, okay, well, what happens once the court makes its determination? You know, the number one thing that I always discuss with individuals at any point in time when they start having these questions is, you've gone to court, you've been sentenced, what happens next? So if you're out on bond, we always ask the court to keep you out on bond and give you the opportunity to self-surrender, as a lot of individuals have significant financial ties in the community. They have significant issues that they may be dealing with within a family unit. So they have certain necessities that they need to tie up and to conclude before they're able to serve their sentence. We will ask for as much time as possible. Sometimes we can even request more time if need be, if you've had no infractions while you've been out on bond. And so we communicate about that. Then we communicate about placement. We communicate about certain locations that could be better for you, how we accomplish and how we achieve communicating with the court about requesting those certain placements. We talk about the appellate process and whether or not you might be eligible for certain parts of an appellate process or not eligible for certain parts of an appellate process. We talk about writs of habeas corpus. There's all types of things that can be discussed, and obviously it depends on what stage you came to see me. If you came to me prior to sentencing, but I wasn't the lawyer that handled your case at trial, we might have an post-conviction appellate issue that revolves around ineffective assistance of counsel, for example. So there could be all kinds of things that we can discuss. This is a really important thing that individuals forget to talk about from the get-go, or lawyers simply don't even talk about this stuff. And so I want to make sure that when we sit down to communicate about your case, that we can communicate about all of these factors that I just discussed with you. These are 9 factors that are the essential ones. They're not all the factors that need to be considered, but I'm more than happy to sit down and talk to you about other things that may revolve around your case, your sentencing, and the other aspects of what a federal case may involve and how it may affect you. I just gave you a lot of information. It's only 9 factors that are to be considered for purposes of sentencing, but we could talk a lot more. If you think I could help you or could be of service to you, click on the link below for a free consultation. Thanks.